Hey guys, welcome to my channel. So we are going to go through that 35-page motion that the prosecution went into detail about why they say Jennifer and James Crumbley should remain in jail. They say that Crumbley's parents ignored needs and well-being of their son, and they have pleaded not guilty to 4 counts of involuntary manslaughter for the deaths of 4 students. So the Oakland County prosecutor filed a court motion on Thursday to ask the judge to keep Jennifer and James Crumbley behind bars. So that's what we're going to go through that document. And there's some pretty interesting things in there that the public wasn't aware of until, well, this document came out. Now, those of you that aren't familiar who the Crumbleys are, they are the parents of Ethan Crumbley. He is the one that went into the school and shot up his school, basically. He's only 15 years old. This is kind of a really important case because it's the first time that parents now are held accountable for their kid for a school shooting. So this is like a kind of a learning lesson for parents that they have to basically be more responsible, and they are going to be accountable for their children's actions if there's reason to believe that they should have been able to stop it, or they should have been able to see the signs, or they should have, well, this motion, this document explains why that the prosecution believes that the parents should be held accountable for this, because all the things leading up to it, it's almost like that the prosecution believes that they would have been aware and they should have taken proper action against their kid, and they should have done things a lot different. So the prosecution believes that Ethan's parents willfully disregarded signs that their son was a threat. And the fact that they took off, you'll see some information in these documents, how it was pretty obvious that they were going to run. And that's why they don't want to lower the bail, because they are at a flight risk. The fact that they took off in the first place. So if they would have just turned themselves in to begin with, maybe they would have got a lower bail. But the fact that they didn't, and they were on the run, they were going to try to run, I believe. They just got caught. And they'll go into some details, more specifics in this document too, about that, about what they did after the shooting that makes the prosecution believe that they were trying to run, and so they should be held in jail. They shouldn't be able to get out because they're a flight risk. Okay, so let's get into this document now. I'm going to go through it and read through everything, and there's some exhibits like the drawings that Ethan drew that day, and just there's really interesting stuff in here, guys. And if you really do want to leave and you don't want to stick around for the video, if you wouldn't mind just hitting that like button on your way out, it really does help out. Okay, so let's get into this, guys. We're going to start at the beginning. Okay, so here we go. State of Michigan and the court for the 52-3 Judicial District. Okay. The people's combined response and brief in response to defendant's motion to modify bond. The people request that the hearing on the defendant's motion be held in person. Bond in this case is properly set at $500,000 cash surety with existing conditions. The most important bond considerations for the court at this time are: defendants are at a greater risk of flight now than they were at the time of the arraignment. As of October 18th, 2021, they were over $11,000 behind on their house payments. Their house is currently for sale. They have sold their horses. They have already shown that they will flee if they get the opportunity. Those are critically important facts known to defendants but not disclosed to the court in the defendant's motion. The case against the defendants is strong, and even stronger than it was at the arraignment when this court properly set the current bond. When defendants left Oxford High School at approximately 10:55 a.m. on November 30th, 2021, over an hour before the shooting, they knew that their son was depressed, that he was fascinated with guns, that they had purchased a Sig Sauer 9mm handgun for him just days before, that he had been researching ammunition while at school, and that he was seen watching violent video of shootings that morning. Before they left the school that day, they had also seen the disturbing drawings attached to this response as Exhibits 1 and 2. So actually, let me show you that. Okay, so here is Exhibits 1 and 2. Here's the drawings. And we'll go through these again once we get to it in the document, but I just wanted to give you a quick look. And then we could zoom in when we come to them again and look at them more closely. But here they are real quick. It says the thoughts won't stop. You got I love my life so much. OHS rocks. Harm legs. What's that say? Art. We're all friends here. Let me see. So this is November 30th at 8:59. So this is on a test. Chapter 5 test review. This looks kind of like a gun, but it's scratched out. Let me see. Now exhibit 1. So here's the gun. It says, the thoughts won't stop. Help me. And then it almost looks like this person is shot, right? Blood everywhere right here. So like I said, we'll go through this again once we get to it in the document, but I just wanted to show you because they brought it up. Here are the exhibits 1 and 2. Okay, so they're saying basically that before the parents left school that day that they had seen these drawings and they just ignored him and they didn't take him home. But I'm still a little bit confused about the school's part, because if they go and they meet with the parents, right? And then, but do they tell the parents to take him home, or do they give the parents an option, or how does that go about? Like, I feel like if the school was so concerned, that the school should have went and got him from whatever class he was at and brought him to the parents and then had the parents take him. Did that happen and then the parents just let him go back? Or did that never happen? Did the parents just, the school just said, oh, here's the drawings, and then they just expected the parents to go find Ethan and then take him? Or did they tell the parents, hey, take Ethan from class, take him home, but they just didn't get him, and so the parents just didn't know where to find him or just left? Or did they go get him from class? But I don't think that was the case. I don't think the school went and got him from his class, brought him to the parents and said, okay, take him home. I don't think that happened. It doesn't sound like it. So I just don't know if the school actually instructed the parents, go get Ethan from class. Or did the school just assume that the parents would just go get him from class? So it's just kind of fuzzy there, like what exactly happened. And I'm sure law enforcement and the prosecution and stuff, I'm sure they know all the details. And I know there was a talk about maybe the school being charged with something. So I don't know. I'll look into that for maybe another video, or when we do the live, because I do want to do a live after this video to discuss this stuff. And maybe I'll try to look into, see if I could find anywhere of that information, which I know before I couldn't find the details of that, but see what's going on with them. Are they charging the school? Because that would be very telling of what the school did, you know? Because if the school had these drawings and then they just met with the parents and just assumed or figured, oh, that's the parents' job, you know, they'll get them out of school, and they didn't like instruct them to take Ethan, and they didn't go get Ethan out of class or show the parents where to find Ethan so they knew where to get him and take him home, then I think they should be held accountable. They screwed up too then, right? Okay, so let's continue with this document. So we did exhibits 1 and 2. Again, these are facts known to the defendants and largely ignored in their motion. In addition, the court should know that defendants had information long before November 30th, within the 6 months prior to the shooting, that their son's only friend moved at the end of October 2021, that the family dog died, that their son was sadder than usual, and that he was sending his mother disturbing texts about his state of mind. Meanwhile, during that same period, defendants spent their time at the barn caring for their horses 3 or 4 nights a week for up to 3 hours at a time, and seeking other relationships, including defendants' mother's extramarital affairs. Instead of paying attention to their son and getting him help, they bought him a gun. Based on those facts, and as further set forth below, the people respectfully request that the court deny defendant's motion and continue the $500,000 bond previously set by the court. In further response to the enumerated paragraphs in defendant's motion, the people state, the people admit the allegations contained in paragraph 1. The people admit that defendant's son was criminally charged with 24 felonies based on events that occurred on November 30th, 2021 at Oxford High School, leaving 4 dead and 7 physically injured and countless others psychologically terrorized. The people admit the allegations contained in paragraph 3. The people admit the allegations contained in paragraph 4. There is still outstanding discovery that the defense and people have yet to receive. The people will continue to provide the ongoing discovery as it is received. Importantly, the facts and information that people rely on in this response were known to defendants without reference to the discovery exchanged. Defendant's motion includes 2 paragraphs labeled 4. As to the second paragraph 4, the people admit that the quoted phrase was used, but deny that it supports the proposition for which defendants cite it. It is not novel to charge a parent for their gross negligence in allowing access to a firearm. See People versus Head, 323, affirming the defendant's involuntary manslaughter conviction in a case arising out of his child's access to a gun in a readily accessible location in the home. People v. Bryson, unpublished per curiam opinion of the Court of Appeals, issued January 16th, 2018. Affirming the defendant's involuntary manslaughter conviction in a case arising out of his child's access to a gun kept in the defendant's closet. So these are other cases where the state's trying to show the parents were charged in past cases for similar situations, basically. Okay, so where are we? Attached as Exhibit 3, what is novel is that such a charge has not been used in the case of a mass shooting at a school. So this is the first case where it's a mass shooting and the parents are held accountable for what the son did because of all these situations that we're talking about. And you'll see as we go through this document. So this will be the first case where it's a mass shooting and then the parents are charged. So let me see Exhibit 3. Let's see what Exhibit 3 is. So Exhibit 3 is, the State of Michigan Court Appeals. Okay, so I'm going to wait till we actually come to this part in the document to read it, Exhibit 3. Because it's basically talking about that case, one of the other cases that they're referencing, and it goes into kind of detail of that case. But I'll wait till we get to it. So those of you that aren't necessarily wanting to hear about that, at least we could get the information specific to the Crumbleys first out there for those of you that just want to hear that. Okay, so let's go back to this. Where are we at? So what is novel is that such a charge has not been used in the case of a mass shooting at a school. What is novel is defendant's purchase of a gun for their son immediately prior to the shooting. This was not a case where their son retrieved and used their gun. Instead, he retrieved and used his gun, the one they bought for him. This case is also unique in defendant's willful disregard of clear evidence on the day of the shooting that their son posed a serious risk to other students. In school shootings, it is not uncommon to find evidence of intent and planning after the shooting has occurred. What is novel about this case is that defendants were made aware in graphic form of the serious risk posed by their son prior to the shooting. This is not a case of hindsight where parents later wish they could have done something. These parents could have done something. Those facts unique to this case meet precisely the definition of gross negligence set forth in the jury instructions cited by defendants M. Crim. JI 1618. The people admit that gross negligence and breach of legal duty are the crux of the allegations in this case. The people admit that the people have the burden of proving defendants were grossly negligent. As to the remaining allegations contained in paragraph 6, the people deny them as untrue. The evidence will show that defendant's son gave numerous warning signs, both in disturbing statements through text messages, journals, and conversations, and in his actions. The evidence will show that by the morning of November 30th, 2021, before their son committed the killings, defendants were aware of his depression, his fascination with guns, the fact that they had purchased a Sig Sauer 9mm handgun for him just days before, that he had been researching ammunition while at school, and that he was seen watching violent video of shootings that morning. Most importantly, their son gave the clearest sign of all that he was intent on violence in his initial drawing on November 30th, 2021, and the modifications he made after the drawing was discovered. The initial drawing is attached as Exhibit 1, and the modified drawing is attached as Exhibit 2. So let's look at that again. Okay, so here are the two. This is the first one, and then this is Exhibit 1, and this is Exhibit 2. This is the first one, and this is the modified one. So let's compare here. So the first one, he has a gun, scratched out the gun. He added RMX 808, not sure what that is. He wrote on the original, "The thoughts won't stop, help me." He kept "the thoughts won't stop," but he scribbled out "help me." Okay. This appears to be a guy or a person, I should say, with a bullet hole, I'm guessing, and basically a pool of blood here. So I'm imagining he's probably like laying down on the ground with a bullet and then blood. That's scratched out. Then he put blood everywhere. He scratched that out. He kept the bullet. He added video game. He kept the crying face. And then he added, I love my life so much. OHS rocks. Oh, that's Oxford High School. So that's his high school, rocks. And then, so originally he put my life is useless, but then he crossed that off. And then he added harmless act. And then this says the world is dead, I think. He scratched that out. And then he added, we're all friends here. So most of it seems like he scratched it out to be like less violent and less like evil or violent, I should say. That's probably the best way to. But then he did add some things that like harmless act, okay. And well, yeah, I guess most of the stuff he was trying to make it look a little bit less violent, right? Yeah, that would be my take on it. There's definitely a red flag here. If you're a teacher and you see this, and then you see that he was looking up ammunition, he just got a gun, and then all the other stuff that we're reading in this document, like it should have been a little bit more of a concern for his parents to say, hey, you know, what's going on? You can't have this gun. You can't have the gun, and lock up the gun. Make sure he doesn't have access to the gun. And make sure after seeing this at the school that he doesn't have the gun with him, because basically what they're saying is they knew that he had access to the gun. All they have to do is go check their house to see if he has the gun. Now you're seeing things like this that he's drawing, and the school's telling the parents that he was looking up ammunition. He was drawing these things on his test review. Wouldn't you, as a parent, go make sure he doesn't have the gun, or hurry up and go home, see if the gun's gone, come back and get the gun from him? Or I would probably have checked first, because you don't want to take a chance of going all the way home. You know, even they said it's 5 minutes, but still that's 5 minutes too long maybe. So just go get him, check his bag, make sure he doesn't have the gun, because the school wasn't aware that he had a gun or access to a gun, but the parents were. So they should have stepped up and either told the school or went themselves and made sure that he didn't have the gun. Okay, so let's get back to the document. Okay, so back to the document. Despite having all this knowledge, defendants failed to take even the simplest action that would have prevented the massacre. All they had to do was tell the school that they recently purchased a gun for their son, ask him where the gun was, open his backpack, or just take him home. The evidence will show that the gun was accessible to their son, and by both of their own admissions, defendants kept the gun in an unlocked armoire cupboard. Further, on the very date of the shooting, defendant Jennifer Crumbley gave inconsistent statements to various individuals regarding the location and accessibility of the gun, including a claim to her boyfriend that she had it in her car. It would only have taken them minutes to ascertain the exact location of their son's gun. Their home was only 1.4 miles from the school, and less than a 5-minute drive. Indeed, we know that, once motivated to do so, defendant's father was able to quickly do just that, drive home and determine that the gun was missing. Defendants were in a better position than anyone else in the world to prevent this tragedy, but they failed to do so. The evidence will further show that these defendants willfully ignored the needs and well-being of their son and the threat he posed to others. Their son was torturing animals, even leaving a baby bird's head in a jar on his bedroom floor, which he later took and placed in a school bathroom. Meanwhile, defendants were focusing on themselves and their own issues, including things like extramarital affairs, financial issues, and substance abuse issues. People deny the allegations as contained in paragraph 7. The people's allegations in the complaint, at the swear to, at the arraignment, and in his response are all consistent. The people admit the allegations contained in paragraph 8. The people admit the allegations contained in paragraph 9. The people admit that pursuant to MCR, the court properly considered the bond factors at the initial arraignment. Moreover, MCR 6.106 provides that the court must state the reasons for its decision on the record, but the court need not make a finding on each of the enumerated factors. In addition, the rules of evidence, other than those regarding privileges, do not apply to proceedings with respect to release on bail or otherwise. MRE 1101, the bond set by this court on December 4th, 2021, was appropriate then, and the changes to the most important factors here, the strength of the people's case, and the risk of the defendant's flight both weigh against any modification of their current bond. The people admit the allegation in subsection A. MCR 6.106 addresses the defendant's record of appearance or non-appearance at court proceedings or flight to avoid prosecution. Paragraph 10B of defendant's motion ignores that question and instead focuses on defense counsel's schedules and text messages that did not include defendants. The relevant facts are that defendants had already retained counsel and knew that they had been charged. Defendants then made a conscious decision not to turn themselves in and instead to flee and hide. It is important to note that defendants' actions are inconsistent with or contradict the statements made by their attorneys to a fugitive apprehension team agent, the FAT agent, to the media, and in the present motion. At approximately 5:33 p.m. on December 3rd, 2021, the FAT agent told, that sounds funny. Oh, silly. I'm going to say, the FAT agent told defense counsel, Ms. Smith, that he would be willing to meet the defendants anywhere in the state to allow them to turn themselves in. Then, at 10:34 p.m., Ms. Smith sent another text to the agent stating that the dad's cell phone died and they have no way to charge it, so some of the calling issues were due to that. But we have Jennifer's number, and they are coming. See attached Exhibit 4. So let's see what Exhibit 4 is. Let's see, created by Timothy Willis. So who's this for? Let's see. Okay, so this is text messages between the Crumbley's attorney, Shannon Smith, and Sergeant D. Hendrick. 12/3/21, 12:15 hours, Detective Hembry and I, Sergeant D. Hendrick, met with attorney Shannon Smith at her office in Bloomfield Township. Smith indicated that she had been contacted by James Crumbley late in the evening on the night before 12/2/21. She stated that Crumbley was concerned about a phone call that he had missed from Sergeant Bryan. She indicated that she told him she would reach out to Sergeant Bryan and find out what he wanted to talk about. Smith stated that she had attempted to contact the Crumbleys multiple times on the morning of 12/3/21. However, none of their texts had been returned. She provided me with the cell phone numbers for herself and her partner. She then sent me a text with her name so I would have it. So, synopsis of text and calls with Shannon Smith. 12/3/21 at 12:28 hours, Shannon Smith. 12/3/21, 17:19 hours. I just walked out of the circuit court, got your message. I'm trying to call my partner. I have about 400 texts and calls I haven't looked at. And then 12/3/21, 7:21 hours sent by me. Thanks. Then 12/3/21, 17:24 hours. It's a hell of a day. My house was listed for sale, so I have my 4 kids and 4 dogs at my office this afternoon and evening while my house is being shown. So I'll get in touch with my partner and figure out what's going on. I told her to tell them that they needed to come back here. 12/3/21, 17:33 hours sent by me. I told Mariel that we would be happy to meet them anywhere in the state so that we can safely and without media take them into custody. If they get pulled over, the officers could conduct a felony stop and have them laying face down in the street. I would like to avoid all of that if possible. Feel free to give them my number and I will give them my word that it will go smoothly. 12/3/21, 22:34 hours. They are terrified because they were expecting me to get info because Karen M. told me she'd get back to me this morning. I do not know where they are, but they assured me they are heading back and will call me so we can get them arraigned. I was in trial all day. Mario was flying back from a family trip to Florida, so our whole day ended up being phone tag and at least 100 people texting us blowing up our phones. My best guess from talking to them is that I'll be texting you at 7 a.m. tomorrow. I wish the media would chill out on this because it's terrifying on top of a huge, sad, awful case. But I'll text you in the AM. I have talked to them by phone several times tonight. The dad's cell phone died and they have no way to charge it, so some of the calling issues were due to that. But we have Jennifer's number and they are coming. 12/3/21, 22:43 hours sent by me. Okay, I understand that they are scared, but their best bet for a quiet surrender is to contact me. 22:44 hours. Thank you. I've told them it needs to be ASAP and they do get it. All right, 2247 hours sent by me. I'm sure you realize the longer they hide, the higher the bond request is going to be. 2247 hours? Absolutely. I would have brought them in today, but I couldn't get any info fast enough. They initially asked if they could go in Monday a.m., and Marielle and I said no. Today was also insane for me personally. I am selling my house, and there was an open house today, so my 4 kids, 4 dogs, and cat were at my office while I was in trial. I'm not normally such a hot mess trying to coordinate things. We will get them in. They wouldn't have paid us what they paid if they planned to run. 2254 hours sent by me. Okay, you have my number. 2247 hours. I called Smith and advised her that the vehicle had been located and that there were several officers, K9 units, and helicopters searching for the Crumbleys. I advised her to contact them and tell them to surrender to us. 2349 hours. I received a call from Smith who stated that Jennifer Crumbley's phone was off and that she was unable to reach her. 28. I still can't get through on wife's phone. Were they apprehended? Sent by me. Not yet, but I bet they're getting cold. Miss Smith also told the media that her clients were making their way back to turn themselves in. The suggestion that either of the defendants did not have access to a phone or could not get a phone charger is not credible. Defense counsel's reference to Dad's phone, singular, omits the fact that the defendants had 4 cell phones when they were found. 2 were phones to replace the phones that were taken into evidence on the day of the shooting. The FAT agent was aware of those 2 phones, had their numbers, and attempted to use those numbers to locate defendants. The other 2 phones were obtained by defendants later, presumably for the express purpose of attempting to evade arrest. That presumption is bolstered by the fact that defendants attempted to destroy one of the phones before they were apprehended. The suggestion that the defendants could not obtain a phone charger is similarly incredible. Phone chargers are available at every CVS, Walgreens, gas station, or corner store. The only thing keeping defendants from getting a phone charger was their desire not to get caught. That is undoubtedly the same reason they parked their car in such a way that the license plate could not be seen from any angle. Defense counsel's statement on December 3rd, 2021, that her clients were making their way back is simply false. Surveillance video of the building where defendants were found shows that they entered the building at 11 a.m. and never left the premises. In short, all of defendants' actions contradict any intention to turn themselves in voluntarily and support that they were fleeing to avoid prosecution. The court must also consider the purposeful attempt the defendants made to evade the authorities. They withdrew a large sum of money from their bank account. They traveled 30 to 40 miles to hide inside of an empty commercial building in Detroit. They turned off their cell phones and purchased 2 additional burner phones. They parked their vehicle in a manner that would make reading license plate less visible. They gained access to an empty commercial building and hid inside a locked art studio for several hours. Even after they had been charged and even after they had been advised by the owner that they needed to vacate his property, they remained inside behind locked doors, seizing all communications with their retained counsel until the fugitive apprehension team apprehended them, and at least one of the 4 burner phones had been intentionally smashed. Lastly, both defendants have substantial contacts with the state of Florida, and based on their prior calculated and deliberate attempt, the people believe the defendants are a serious flight risk. The people deny the allegations contained in subsection C. In their written and video recorded statements, several witnesses have stated that both defendants have substance abuse issues. The people deny the allegations contained in subsection D. As set forth above, the discovery tendered thus far confirms that defendants themselves had every reason to know that their son was a danger to others. MCR 6.106 expressly makes the seriousness of the charge a relevant consideration, and the people agree with defendant's statement that this case is obviously very serious. Further, as explained in the second paragraph 4 above, the charges against defendants are appropriate and the probability of conviction is high. The people neither admit nor deny the allegations contained in subsection F and leave defendants to their proofs. The people lack sufficient information to either admit or deny the allegations contained in subsection G. The people request that the defense provide the people and the court with the name and contact information, as well as an offer of proof for any individuals who are willing to vouch for these defendants. To the extent that information is not provided on or before January 4th, 2022, the people request that the court not consider such unidentified supporters when deciding this motion. The people deny the allegations contained in subsection H. Defendants have knowledge of important information contradicting those allegations that they failed to disclose to the court. For example, as of November 1st, 2021, defendants were over $11,000 in arrearage on their house payments. See Exhibit 5A and B. And they are working to list the home at, see Exhibit 6. So Exhibit 5A and B and Exhibit 6 are not on this document for some reason. I mean, they're supposed to be, but I don't know if it's just not public, because instead of 35 pages, it only gives us 30. So maybe that stuff is sealed. Let me know if any of you guys have seen the last 5 pages. Okay. Let's continue here. See Exhibit 6, like I said, that's not on here either. Thus, defendants will no longer have any strong ties to Michigan, nor will they own any real property in Michigan. So we know that's a flight risk. I mean, that's if they don't have it's one of the things they look at for bail, if they're going to offer somebody bail, because are they connected to a place? I mean, do they have a home in a certain area where their home is, where they're supposed to be staying? Or are they a flight risk? Are they going to just take off because they have no connection, nothing, no things that are keeping them anywhere? So they're more of a flight risk. Okay, so it is worth noting that by maintaining that there is no conflict in joint representation and by making no distinction between themselves in the present motion, defendants imply that they are tied to each other, that the only risk of flight is that both will flee or neither one will flee. The facts already discovered show that defendant mother was having at least one intimate affair. When defense counsel shares the explicit videos found on defendant mother's cell phone, it is possible, even likely, that defendants will go separate ways. Defendants have already made it clear that their son's presence will not keep them here. The people neither admit nor deny the allegations as contained in subsection I, and leave defendants to their proofs. The people neither admit nor deny the allegations contained in paragraph 11. It is well established that defendants should not be speaking with any listed witnesses or potential witnesses, many of whom are as yet unidentified. The people assert that defendants' prior statements and actions call into question any such promises on their part. The people admit that there remains outstanding discovery. The people deny the remaining allegations as untrue. The people admit the allegation contained in paragraph 13 that setting bail is appropriate. The people maintain that the bond previously set by this court was and is appropriate. As set forth above, to the extent additional facts have come to light or that circumstances have changed since the arraignment, that new information supports the current bond and recommends denial of the present motion. Wherefore, the people respectfully request this honorable court deny defendant's motion to modify bond in its entirety for the reasons stated above. Respectfully submitted, Karen D. McDonald, prosecuting attorney. And then we got Mark A. Keese, assistant prosecuting attorney, December 23rd, 2021. Exhibit 3, that's that other case. So let me see what else real quick, and then we'll go back to that for those of you who want to hear about the case that they use as a reference. Like another case where the parents were charged. So yeah, the Exhibit 4 are those texts that I read between the defendants or the Crumbley's attorney and one of the sergeants, which would be Sergeant Hendrick, it looks like. So basically, you know, their attorney's saying that, oh yeah, they're going to turn themselves in, blah, blah, blah. Their phone just doesn't work. And basically making excuses. Now, whether or not the defendants were giving those excuses to the attorney and the attorney was just relaying, well, you know, what they were saying. And also, was the attorney aware that if that is really what the Crumbleys were telling the attorney, was the attorney actually aware that, oh, this is bullcrap, they're lying? I mean, how aware was she that they were full of it? They weren't going to turn themselves in. And I'm sure she probably was, at least maybe not at first, but then as she was seeing how things were going and the excuses, you'd think she would be aware that it was just bull. But I mean, she's working for them. So that she was, in a way, I guess, doing her job. I mean, this is what they're telling her. Or this is what they want her to relay back to the law enforcement, so that she was just doing her job. That's what she was doing, I feel like, right? I mean, what do you guys feel like? The attorney should have done something different, or definitely the parents should have done something different. I know that. Okay, so let's that's about it besides this reference case we'll read here. Remember that, so this is the case they referenced, the state referenced up there in one of those pages of the documents. Okay, let's see. This is through it. The State of Michigan Court of Appeals, People of the State of Michigan versus Curry Dell Bryson. All right, defendant was convicted. Oh, wait, let me make this bigger, actually. So, defendant was convicted by a jury of involuntary manslaughter and possession of a firearm during the commission of a felony. He appeals as of right. We affirm. Defendant's convictions arose from the shooting death of 3-year-old Elijah Walker at defendant's home by defendant's 11-year-old son, CL, with a gun that defendant kept in his closet. Defendant was at work at the time, and Elijah's mother, Denisha Walker, was supervising her own 3 young children and defendant's 2 children. On appeal, defendant contends that the evidence was insufficient to convict him, that his trial counsel was ineffective by failing to present his defense, and that his due process rights were violated when he had 2 preliminary examinations in front of different judges. The court reviews de novo a challenge to the sufficiency of the evidence. Claims of ineffective assistance of counsel that are unpreserved are limited to review for errors apparent on the record. The constitutional question of whether an attorney's ineffective assistance deprived a defendant of his Sixth Amendment right to counsel is reviewed de novo. So here's a picture of Elijah Walker. He's the 3-year-old that actually was shot by the 11-year-old. The 11-year-old, since he's a minor, I cannot find a picture of him. And they don't mention his name, at least I didn't do like a deep dive, but I just tried to Google, and it will not give the name because he was charged as a minor, which means he'll be out by 21, they said, maybe sooner. But they won't give his name. So I think his initials are CL because they call him CL, but they don't have a picture, and they don't say his name in any of the articles. But this is Elijah Walker. That's the little boy that he shot. And then here is the dad of the 11-year-old that ended up getting charged. Okay, so before we get back to the documents, I just wanted to show you this that I found too. So here's the dad, the one that gets charged. I mean, they both get charged. The 11-year-old son gets charged as a minor, and then the dad gets charged, as you'll see as we go through the documents. Spoiler alert. but you'll see. See, look, this is what happened here. Okay, so just gives his information. Oh, 10/10. It's a day before my birthday. My birthday's 10/11. He's a Libra too. Anyway, so he is discharged as of now. He got discharged on 7/2/21. And I believe this was from 2015, around that time. So it looks like he spent 6 years in jail? Around 6 years averaging, because I'm not sure, I think it happened around 2015, not sure, when the trial was and how that all went. Well, I'm sure he probably was in jail waiting for trial. I'm not sure. So yeah, so it looks like he spent averaging around 6 years, it looks like, that he spent in jail. So, oh, there we go. Date of sentence. So date of offense was 8/3/2015 and date of sentence was 2016. So he spent 5 years in jail, but he may have been in jail waiting for the trial, depending on when they actually arrested him. And then he probably got time served or whatever he served before the trial, I'm guessing. So yeah, around 5 or 6 years, we could say. So he had minimum 2 years, maximum 15 years. So he got more on the lower end, I would say. Still a little bit more than the minimum. I mean, it's a long time. 5 or 6 years, a long time to spend in jail. And let me know once you hear the specifics of this case, if you think it was fair, what you think. I don't know. I tell you, I think for this Crumbley case that it makes more sense that the parents should be charged because of all the things they ignored, and they were just very negligent. They really were. But with this case, it's a little bit less obvious because, well, you'll see some of the facts. I'm not sure if I agree that he should have been charged And if so, maybe a lesser charge. I would have given probation. I mean, or like a couple years, but I don't know. I don't know. So all I know what's in this document that I'm reading to you guys. So maybe there's more to it that came out that I'm not aware of, but let me know after you hear this information of at least what's in the document and see if you think that this should have happened for Curry. Okay, so let's get back to the document. Sufficiency of the evidence. Defendant first argues that the evidence was not sufficient to convict him. Due process requires that evidence of every element of a crime be proved beyond a reasonable doubt in order to sustain criminal conviction. To determine if the prosecution produced evidence sufficient to support a conviction, this court considers the evidence in the light most favorable to the prosecutor to ascertain whether a rational trier of fact could find the defendant guilty beyond a reasonable doubt. Direct and circumstantial evidence, as well as all reasonable inferences that may be drawn, are considered to determine whether the evidence was sufficient to sustain the defendant's conviction. In order to demonstrate that defendant was guilty of gross negligence amounting to involuntary manslaughter, the prosecution had to prove beyond a reasonable doubt defendant's knowledge of a situation requiring the use of ordinary care and diligence to avert injury to another, his ability to avoid the resulting harm by ordinary care and diligence in the use of the means at hand, and his failure to use care and diligence to avert the threatened danger when, to the ordinary mind, it must be apparent that the result is likely to prove disastrous to another. Defendant disputes that the third element, causation, was satisfied because his actions were not the factual approximate cause of Elijah's death. The causation element of criminal negligence amounting to involuntary manslaughter consists of two components: cause in fact and proximate cause. Factual causation is a determination regarding whether a defendant's conduct was a factual cause of the result by assessing whether the result would have occurred but for the defendant's actions. In other words, if the result would not have occurred absent the defendant's conduct, then factual causation exists. Here, the parties stipulated that 11-year-old CL used defendant's .45 caliber gun to shoot Elijah, causing his death. Defendant made a statement to Detective Patrick Lane that he kept the guns in the closet in his bedroom, and crime scene technician Nathan Johnson observed two weapons in defendant's closet in the hours after the shooting. The .45 caliber firearm was on the top shelf of the closet, 81 inches off the ground, and an assault rifle was in the corner. Furthermore, defendant knew that CL had been caught near his mother's house shooting a different gun mere days before he shot Elijah. Defendant also knew that CL had found and was playing with his .45 caliber gun 2 years earlier. Thus, but for defendant keeping a loaded firearm in his closet, while knowing that CL was aware of the gun and had access to it, and had been involved in obtaining and shooting guns on his own, including the one used to shoot Elijah, Elijah would not have been killed. Defendant's actions were a factual cause of Elijah's death. The prosecution must also establish that defendant's actions were the proximate cause of Elijah's death, so that defendant is not convicted based on conduct that is too remote or unnatural. For defendant's actions to be a proximate cause, the victim's injury must be a direct and natural result of the defendant's actions. Defendant argues that he used ordinary care to ensure that CL could not acquire the gun by arranging for Walker to supervise CL, coming home from work to confirm that CL was supervised, and checking to see that the bedroom door was locked. Walker testified that she was at defendant's home when defendant called her from work to ask her to watch his children, SB and CL, who their mother would soon drop off at defendant's home. Walker said that after defendant's children arrived, she went to the store with her children and her sister and SB, while CL remained at defendant's house with an adult resident of the home, Donald. Defendant told Detective Lane that SB called him and Walker was not present, so defendant called repeatedly to ensure that CL was monitored. Walker reported that defendant was home when her group returned from the store and she did not see Donald before defendant returned to work. Defendant told Detective Lane that he checked to make sure the bedroom door was locked when he was home around 11 a.m. Walker reported that she too checked the door to defendant's room after he returned to work and found it locked. Despite some effort by defendant to monitor CL, there was sufficient evidence for the jury to find beyond a reasonable doubt that the defendant failed to use care and diligence to prevent CL from obtaining and using his loaded firearm, causing the death of Elijah. As stated, the defendant was aware that CL had a history of unsupervised involvement with guns, including possessing and shooting one without permission in the days before he shot Elijah. Defendant also knew that he had to safeguard his firearms from CL because CL had found a .45 caliber weapon a couple years before the shooting and was playing with the gun, causing defendant to decide to keep his bedroom door locked. Defendant explicitly told Detective Lane that he was concerned about CL on the date of the shooting because CL had recently obtained a gun and would often snoop around the home. However, defendant could not have ensured that his bedroom door was locked before he went to work that morning because Walker reported that she slept in defendant's bedroom the night before and she shut but could not lock the door when she left the room after defendant had gone to work. Walker reported that defendant's closet door did not have a doorknob, and there was no evidence that the closet door had a lock, that the bedroom windows locked, or that the guns were stored in a locked case or equipped with trigger locks. Thus, defendant's failure to secure or disarm the gun while CL was at the house, particularly in light of CL's apparent fascination with firearms, including the one that was used to shoot Elijah, was sufficient for the jury to find beyond a reasonable doubt that Elijah's death was a direct and natural result of defendant's actions. Okay, so I just want to add something. I'm still a little confused. It sounded like they said the bedroom door was locked, and then you come to this part and it makes it seem like she didn't lock the bedroom door. So, I mean, I guess that would be very important. Was the bedroom door locked or wasn't it? And I guess he should have not had the gun loaded. I mean, yeah, I guess why would he? So the more I'm thinking about it, if he knew his son would like to snoop around, fascinated with guns, and he should not have had it loaded. So, I don't know. Yeah, maybe he should have been charged. But I just want to know, was the bedroom door locked or wasn't it? Because I think that's, kind of a big deal. Because if he did lock the bedroom door, then he figured maybe his son couldn't get in there. And that he would have to break down the door. And if he was being supervised by an adult, it would have been hard for him to sit there and break down a door or bust, somehow open the door without the adult, whoever's supervising him, be aware that he's doing that. So I don't know. Just let me know what you guys think. I'm going to continue. Defendant argues that Walker's and Donald's failure to supervise CL closely enough to prevent him from accessing the gun was an intervening and superseding factor, negating defendant's actions as a proximate cause of Elijah's death. Where an intervening cause supersedes a defendant's actions as a legally significant causal factor, then the defendant's conduct will not be deemed a proximate cause of the victim's injury. Whether an intervening cause supersedes and severs the causal link is a question of reasonable foreseeability. The court in Schaefer discussed the analysis as such. The linchpin in the superseding cause analysis, therefore, is whether the intervening cause was foreseeable based on an objective standard of reasonableness. If it was reasonably foreseeable, then the defendant's conduct will be considered a proximate cause. If, however, the intervening act by the victim or a third party was not reasonably foreseeable, for example, gross negligence or intentional misconduct, then generally the causal link is severed and the defendant's conduct is not regarded as a proximate cause of the victim's injury or death. Undoubtedly, as Walker admitted, she lost sight of CL while she was supervising him. However, the fact that the adults who were supervising CL in defendant's absence were unable to prevent CL from obtaining the firearm was reasonably foreseeable. Most notably, neither adult was aware that there was a gun in the home. Further, Walker was asked to supervise defendant's 2 children while she already had her own 3 young children with her, and Donald reported that he left for the day shortly after defendant's children arrived, leaving them in Walker's care. It was not clear from the evidence whether CL obtained the gun by entering defendant's room before he returned to lock it, by entering through an unlocked window, or by some other method. However, it was reasonably foreseeable that Walker and Donald could not keep CL away from a gun that they did not know about. particularly when there were 4 younger children to supervise. Likewise, their failure to fulfill a responsibility of which they were not aware cannot be considered grossly negligent or characterized as intentional misconduct. In sum, when viewed in the light most favorable to the prosecution, the evidence was sufficient to find beyond a reasonable doubt that the defendant's actions were the cause of Elijah's death and to convict the defendant of involuntary manslaughter. Effective assistance of counsel. Next, defendant argues that his trial counsel provided ineffective assistance by failing to show the jury a portion of surveillance video and not requesting an instruction regarding proximate cause. A defendant's right to counsel is guaranteed by the United States and Michigan constitutions. This right to counsel encompasses the right to the effective assistance of counsel. In order to demonstrate an effective assistance of counsel claim, a defendant must show that counsel's performance was deficient and that counsel's deficient performance prejudiced the defense. A counsel's performance is deficient if it fell below an objective standard of professional reasonableness. Effective assistance of counsel is presumed and the defendant bears a heavy burden of proving otherwise. Defendant must also show that the resultant proceedings were fundamentally unfair or unreliable. Defendant argues that the performance of his trial counsel was deficient because he failed to display evidence or request jury instructions that supported his theory of defense, i.e., that his negligence did not cause Elijah's death. The United States Constitution provides criminal defendants with the right to present a complete defense. Few rights are more fundamental than that of an accused to present evidence in his or her own defense. Criminal defendants have the right to submit evidence that could influence the jury's determination of guilt. Defendant contends that his trial counsel should have presented the home surveillance video of CL. Defendant asserts that he watched the videotape of the surveillance cameras and he saw footage of CL going toward the back of the house, and it was clear that he went in the window and retrieved the gun in the morning while Miss Walker was at the store with the other children. Defendant submitted an affidavit similarly stating that the surveillance video showed CL walking unsupervised to the back of the house and then into the vehicle where Elijah was shot. However, defendant's assertion concerning the video was contradicted at trial. Johnson testified that there were 4 security cameras on the home, with the monitors in the defendant's bedroom, and that the backyard camera showed an alley, garage, and a portion of the car where Elijah was shot. Police Sergeant Stephen Ford extracted video from the surveillance system for the period between 12:30 and 1:19 p.m. on August 3, 2015, some of which played for the jury, and Ford reported that none of the cameras pointed at the window of the defendant's bedroom. Thus, apart from the defendant's unsubstantiated assertion, there is no reason to believe that the additional surveillance footage would have showed CL entering the house through the defendant's bedroom window. And the performance of defendant's trial counsel could not be deficient for not presenting evidence that was unavailable. Most significantly, defendant's theory that the failure of the other adults to adequately supervise CL allowed CL to obtain and use the gun was presented to the jury. As stated, Walker testified that she could not lock the bedroom door after she left the room in the morning, that she left CL at the home with Donald while she took all the other children to the store, and that she lost sight of CL after returning to the home. Defendant's trial counsel argued in closing that the defendant took ordinary care to ensure that the adults were supervising CL, including coming home to make sure CL was supervised and the bedroom door was locked. Counsel also emphasized that defendant locked the gun in his bedroom and that it was unknown how CL acquired it. Thus, defendant's closing argument squarely placed the responsibility for supervising CL during the time he was thought to obtain the gun on the adults the defendant trusted to supervise his children, and the performance of defendant's trial counsel regarding the presentation of the surveillance video did not deprive defendant of presenting this defense. Counsel's performance will be deemed to have prejudiced the defense if it is reasonably probable that, but for counsel's error, the result of the proceeding would have been different. The parties stipulated that CL used defendant's gun from his closet to shoot Elijah. Defendant argued in closing that the evidence did not demonstrate how CL accessed the closet, just that the defendant had locked the door and other adults were supervising CL. However, while acknowledging that it was unknown how CL obtained the gun because he was sneaking, the prosecution maintained that the manner in which CL retrieved the gun was irrelevant because defendant's gross negligence was in failing to adequately secure the gun from CL. Thus, evidence suggesting that CL may have obtained the gun by sneaking through the window would not have exonerated defendant because the jury knew of that possibility and was asked to decide the case based on the defendant's level of negligence in failing to properly secure the gun. Defendant argues that the performance of his trial counsel was deficient in failing to request a jury instruction regarding proximate cause and intervening and superseding events. A defendant has the right to a properly instructed jury. The trial court is required to instruct the jury concerning the law applicable to the case and fully and fairly present the case to the jury in an understandable manner. Jury instructions must include all of the elements of the charged offenses and cannot exclude material issues, defenses, and theories where there is a supporting evidence. The trial court instructed the jury there may be more than one cause of death. It is not enough that defendant's act made it possible for the death, though, to occur. In order to find the defendant caused the death of the victim, you must find that the death was a natural or necessary result of defendant's act. That is, you must find beyond a reasonable doubt that the harm which resulted from the defendant's conduct was to an ordinary person a reasonable foreseeable consequence of the conduct. As stated, for defendant's action to be a proximate cause, the victim's injury must be a direct and natural result of the defendant's actions. And the trial court instructed the jury accordingly. Further, by instructing the jury that the resulting harm must have been a reasonably foreseeable consequence of defendant's conduct, the trial court effectively conveyed to the jury the legal significance of intervening and superseding causes, because whether an intervening cause supersedes and severs the causal link is a question of reasonable foreseeability. Although the trial court did not specifically use the terms intervening cause or superseding cause, there is no error where the instructions fairly presented the issues to be tried and sufficiently protected the defendant's rights. Counsel was not ineffective for failing to make a futile objection to the jury instructions. Preliminary examination. Lastly, the defendant argues that his due process rights were violated when he had a second preliminary examination in front of a different judge. Unpreserved claims are reviewed for plain error affecting substantial rights. Reversal is warranted only if the plain error resulted in the conviction of an innocent defendant or if the error seriously affected the fairness, integrity, or public reputation of judicial proceedings independent of the defendant's innocence. At defendant's first preliminary examination on September 8, 2015, District Court Judge Ronald Giles dismissed the charges against defendant because there was no evidence that demonstrated what gun had been used by CL. A second preliminary examination was later held before District Court Judge Lydia Nance Adams. Judge Nance Adams incorporated the record from the first preliminary examination and heard additional evidence in the form of a ballistics report before binding defendant over to a circuit court for trial. With regard to preliminary hearings, MCR 6.11 provides, if, after considering the evidence, the court determines that probable cause does not exist to believe either that an offense has been committed or that the defendant committed it, the court must discharge the defendant without prejudice to the prosecutor, initiating a subsequent prosecution for the same offense, or reduce the charge to an offense that is not a felony, except as provided in MCR 8.11. The subsequent preliminary examination must be held before the same judicial officer, and the prosecutor must present additional evidence to support the charge. Okay, MCR 8.111 provides that the chief judge may reassign a case if a judge is disqualified or for other good cause cannot undertake an assigned case. Thus, because there was no reason of the record that Judge Giles was unable to preside over the second preliminary examination, the district court erred in not holding the subsequent preliminary examination before the same judicial officer. However, we do not agree that defendant's due process rights were violated as a result of the error. Subjecting a defendant to repeated preliminary examinations violates due process if the prosecutor attempts to harass the defendant or engage in judge shopping. Among the factors to be considered in determining whether a due process violation has occurred are the reinstitution of charges without additional non-cumulative evidence not introduced at the first preliminary examination, the reinstitution of charges to harass and judge shopping to obtain a favorable ruling. Here, the later availability of the ballistics report necessitated the subsequent preliminary examination, indicating that the prosecution's motive was not to harass the defendant. Additionally, there's no evidence from which we can conclude that the prosecution had any control or influence on the assignment of the case to a different judge. Both parties agreed with the procedure set forth by Judge Nance Adams, as did the defendant himself. Further, defendant never requested a transfer of the case or objected to the second judge, and the prosecution never argued for having the case remain before the second judge. These facts suggest that the assignment of the defendant's second preliminary examination to Judge Nance Adams was a procedural error or oversight and not motivated by improper judge shopping. Finally, for constitutional purposes, the dismissal of a case by a court following preliminary examination does not bar a subsequent arrest, examination, and trial for the same offense because the defendant had not been placed in jeopardy. In any event, the error does not require a reversal because defendant cannot demonstrate that it affected the outcome of his trial. Defendant does not argue that the evidence of the second preliminary examination should not have provided probable cause to bind him over. Further, defendant was convicted beyond a reasonable doubt of 2 of the 3 accounts for which he was bound over. Thus, the jury, in effect, endorsed the decision of the district court by finding that the prosecution's evidence met a higher standard of proof than that required to bind defendant over. As noted in People v. Hall, provides that any error of procedure is not error requiring reversal if the error was harmless. An error does not result in the miscarriage of justice where it had no impact on the outcome of the trial. Okay, so that's that. After hearing all that, what do you guys think? Do you think this charge is reasonable? They should be charged? Do you think they should be held accountable? Let me know your thoughts. Maybe we'll do an upcoming live and discuss this. But until then, share your thoughts in the comments and have a good day. Bye.
Really, 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 really need your love. I'm begging you to be kind. I'm begging you to be kind.